A diner eats a lavish meal at a high-end restaurant. The check is imminent. They reach for their wallet and realize they have no money. Rather than confessing to the manager, they wait for the waiter to look away, leave the table, and sneak out the back door. Based on these specific facts, which statutory charge secures a conviction? The Theft Act 1968, the Fraud Act 2006, or the Theft Act 1978? Charging standard theft under the 1968 Act fails immediately. Following the precedent of Edwards v. Ddin, the actus reus of taking the food and the mens rea of dishonest intent must coincide. Because the diner only became dishonest after the meal was finished, the timeline of theft is broken. To secure a conviction, we must navigate the statutory architecture of the Fraud Act 2006 and the specific safety net of the Theft Act 1978. In property offenses, the exact millisecond a defendant's intent crystallizes dictates the entire legal outcome. We begin with the first alternative charge, Section 2(1) of the Fraud Act 2006, fraud by false representation. This flowchart breaks down the offense. The actus reus requires a false representation, express or implied, even against a machine. The mens rea requires proving dishonesty via the objective Ivy test, plus a specific intent to make a gain or cause a loss. We can apply this statute to our restaurant scenario using the IRAC method and the precedent of DPP v. Ray. The issue: does sitting at a restaurant table constitute an ongoing promise to pay? The rule: yes. Conduct acts as a continuing representation of present intention. Applying the rule, the moment our diner decides not to pay but remains seated, the implied representation becomes false. Liability attaches at that exact moment. A critical examiner warning: do not look for a deceived victim. Section 2 of the Fraud Act is focused entirely on the conduct of the defendant. The offense is complete the millisecond the false representation is made, regardless of whether any actual money is lost or any person is actually misled. Sections 3 and 4 of the Fraud Act cover the pathways for prosecuting what a defendant fails to do. Figure 10.2 outlines Section 3, failing to disclose information. The actus reus shifts to omission. Silence is only criminal if a strict legal duty to disclose exists, like in insurance contracts or statutes. A moral obligation to speak up is insufficient. Section 4, fraud by abuse of position, applies when a defendant occupies a position where they are expected to safeguard the financial interests of another. To see how broadly the courts interpret a position of financial trust, we look to R.V. Valuyev's, where unlicensed gangmasters exploited migrant workers. Because the gangmasters controlled the workers' wages and rent, they were legally expected to safeguard those financial interests. Their unlawful deductions constituted a criminal abuse under Section 4. Under the Fraud Act framework, weaponized silence and exploited authority carry the same statutory weight as a direct lie. But what if the diner simply dashes out the moment they realize they have no money, without pretending to pay? They made no false representation. Section 3 of the Theft Act 1978, making off without payment, was designed to plug this exact temporal gap. The actus reus requires that goods or services were supplied, and that the defendant made off from the specific spot where payment was required. The intent requirement is clarified by R.V. Allen. The prosecution must prove the defendant intended to avoid payment permanently. Someone who makes off intending to return and pay later cannot be liable for this offense. Contrast this with R.V. Vincent. If a defendant dishonestly convinces a manager to let them pay later, the 1978 Act fails because payment is no longer expected on the spot. While the 1978 Act fails in the Vincent scenario, the prosecutor can now charge Fraud Act Section 2 for the deceptive agreement itself. One final examiner warning regarding Section 3 of the Theft Act: the underlying service must be legally enforceable. Running out on an illegal service, such as prostitution, cannot trigger a charge under the 1978 Act because the debt itself has no legal standing. Section 3 of the 1978 Act is a highly specific tool used for enforceable debts where the defendant permanently flees the scene without a word. Returning to our hook, the diner realizes they lack money midway through the meal. Under DPP v. Ray, if they stay seated to lull the waiter, the charge is Fraud Act Section 2. If they panic and bolt instantly, it's Theft Act Section 3. Real-world prosecutors recognize that these offenses frequently overlap on the same factual evidence. High-scoring answers reflect this reality. Identifying multiple applicable statutes ensures the prosecution's case covers every possible shift in the defendant's mindset. In the law of fraud and making off, the difference between a conviction and an acquittal often comes down to a single second on the timeline of intent.